Okay. Good morning, all. This is former Judge Deborah Garrett convening this meeting of our work group. And Jill, do you just make notes of who's here, or do we need to recite who's here? Jill?
Sorry. Yeah, no, we don't need to do a roll call. We're fine.
Okay. Okay, so we're ready to start our meeting. Can you all see me? My screen kind of went down, so I can't see. Well, I can see little postage stamps of you. Okay. So those of us who left the last meeting with work assignments can report on their work assignments. I'll start out. It's a short report. I was going to redraft the letter to the advocacy groups and hopefully invite the advocacy groups to a feedback session with our group to occur at some point, we hoped, before this meeting. But as usual, you plan for things to happen much sooner than they actually happen. As we went through the letter to the advocacy groups, which Stephen had taken the lead oar on and had written a really good but very complex draft on, we ended up deciding that really it's not going to be productive to approach these groups with a detailed discussion of the risk assessment tool and the various criticisms and support of it, unless and until the people we're approaching know the background a lot better, including the legal, the legal procedures and how the pretrial processes all work. So then we decided, well, maybe we wanted simply meet with the advocacy groups to talk generally about the pretrial process. The normal pretrial process for the court, as we all know, has been suspended for the past year, and the court's been working off the Supreme Court order of last March, I think, which said basically, unless there's a really high risk of violent crime, people should be released pre-trial. And our judges have been operating, and I painted that with a pretty broad brush, but really our judges have been operating under a process of releasing almost everybody except the people that clearly pose safety risks. And I imagine that order is still in effect. Is that true, Judge Freeman?
Modified version, but yes. Okay.
So we've been, so the statistics that we will get from this past year aren't going to be statistics that are from the pretrial risk assessment, because we haven't been using the assessment. Instead, the judges have been following the Supreme Court order, which is to release lots of people. And we'll talk about this more when we go through Dr. Peterson's numbers. And there we are on that. Do we have Dr. Peterson still with us?
Yes, Judge Garrett, I'm here.
Oh, okay, good. I couldn't see you on the row of pictures I have on the right side of my screen. My Zoom skills are not nearly real good, so, okay. All right, so we'll talk more about the fact that normal procedures have been suspended when we get into the information Dr. Peterson will be sharing with us and has sent to us. In addition, we reached out to Katrina Michaels and Shuling Zhao, who are the people who are likely to be heading up the county's task force on racial equality, and look to get some input from them. I finally connected with Shuling. We had some, Stephen started the process and talked with them generally, but then there was some, he didn't hear back from them, and I got into it because I know Shuling, so I know Shuling from when she was in high school, and so I got in touch with her, and I heard back finally. They are putting a big initiative before the county tomorrow, so Shuling didn't have time to talk with me before our meeting today. She and I have a phone meeting set for Thursday, so in 2 days we will have made that connection, but that's where we are. And in the meantime, and John and Dave, you can correct me if I'm wrong, but I believe that the judges authorized resumption of the pretrial risk assessment form, or authorized resumption of using that form, but only quite recently, like within the last week or two. And we're going from there. So we're going to get the numbers that we would have gotten a year ago, or would have started getting a year ago, if it hadn't been for the way everything changed for the last year. Now the court, my sense of it anyway, is that the court is getting somewhat back to normal in its procedures. It's available for jury trials, and although there haven't been very many jury trials since the court made jury trials available, there has been a big increase in settlement of cases that are on the brink of trial, which is the pattern in criminal cases. They don't generally settle till they get pretty close to trial. So I think we're starting to enter into a more normal period, hopefully one which will yield us some good statistical information that we haven't been able to get, at least not in quote normal form, over the last year. And but the bottom line is that we have not actually set up or arranged for a meeting with the advocacy groups. I think the questions about the risk assessment form and process are, and well, the questions about the pretrial process in general, I think, are big enough. They're bigger than the risk assessment tool. And if we're going to ask for input from racial advocacy groups, I think we should be looking to get input on the whole picture, not just the use of the risk assessment tool. But I don't know. That's a question for our committee to answer. That's the long way of saying what I've done since the last meeting, though, which is not very much, but a little bit, and here we are. Stephen, you came away from our last meeting with some homework assignments too. What's your report?
Would you please remind me what those homework assignments were?
Well, actually, they were that you were going to get in touch with Shuling and Kristen, which you did.
Yeah.
And I've just reported on that. I think I may have covered your report for you.
I think you did. I don't think you had anything else. The other thing that I would just add to your update, Judge Garrett, is in the task force as a whole, we have talked about the influx of money from the American Rescue Plan Act, and the opportunity that affords the task force, along with everyone else in the community, to recommend places to allocate some of that money. Good. And in my thinking, I recall our conversation where everyone that was being released under the governor's orders and the Supreme Court orders was essentially getting the same level of minimal monitoring from John's office.
Yes.
And that was for lack of staff, that John and Jake just couldn't handle the load to do anything more than the bare minimum of monitoring. So I'd just like to propose at some point at an appropriate time for this committee to consider whether or not we might want to encourage the task force to endorse another FTE for John's staff that would allow us to more appropriately monitor the different tiers of risk that adopting the PSA might call for once we're back in full swing for pretrial release. That's the only thing I would add to the current status report.
All right, thank you. And I know Judge Freeman took on a task too, but before you report on that, I'd just like to ask John. John, you are with us, right? John
Yes.
Krause?
Yep.
Good. Again, I can't see everybody. And anyway, how are things going with your department? And if you have a reaction to Stephen's suggestion well, let's at least mark it down for discussion, if not right now, later in our meeting.
Yeah, we're doing all right, and I really appreciate Stephen coming to the plate with that, or bringing that up. I'm bringing up his email, and this federal funds would be if we could pursue that, because I know we're on a budget freeze for a while. Dave's not here, but I think through 2022 at least things are frozen, and so if any federal help or grant or anything like that would be great. If we're looking to go into full swing, we're going to want this department to be able to have a catchment, with.
Yeah. And your department has been understaffed with just the two of you from the beginning, because that's all the county could afford. And of course, the funding that the county appropriated for your department was for 2021 and 22, I believe. So there's a finiteness to that funding. And we anticipated, of course, that we'd have 2 years of success by the time we came to the next budget. And your department would be perhaps better funded and certainly retained. And frankly, this American Recovery Act gives me hope that we may be able to fill in some of the gaps that the very broke county isn't going to be able to fill in. This pandemic cost the county a lot of money, and I think things will be frozen for quite some time to come. So if there's potential for funding from the Recovery Act, that would be really, really welcome, I think, for our work. And it sounds like you feel the same way, John.
Yes, I totally concur. I think that would be a great move at some point.
Okay, good. And Judge Friedman, you want to tell us about any information you've gathered? I think you just were going to talk to Damani Johnson, and I'm not sure that and you were going to report on things with the court and the status of criminal cases now. Why don't you take it?
Yeah, well, the short answer with Damani is I haven't had a chance to catch up with Damani yet, but working on that actually presently. As far as an update for what has been going on, yeah, first of all, I do wish Dave were here on the budget issue, because I think as Judge Garrett indicated, I'm not sure it's a matter of adding an additional FTE or whether it's just securing funding for a longer term.
Yeah.
Because that's my bigger concern is that we have the funding to keep it going. And John can correct me if I'm wrong, but it wasn't simply just a lack of staff during the last year. A lot of it was, John, for safety reasons, they weren't meeting in person with individuals. So essentially that left the same level of supervision for all three groups. Am I correct in that, John?
Yeah, very correct. The lowest two levels, there was no contact made except for the initial intake, and then the highest ones made electronic contact weekly. But yeah, there was no face-to-face contact since I think April 1st now this year. It lifted since April 1st last year, so about a year.
Yeah. But then April 1st, you started that back up, correct, in person?
Correct.
Yeah. And then a week ago, we re-implemented the risk assessment tool a week ago Monday, I believe. So we've had about six or seven court days now. Haven't had a chance to really examine how that's working out with the commissioners yet. We have a judges meeting on Thursday. Hopefully we'll have a chance to discuss that with the commissioners, get some perspective from them as to how that's working. But it was re-implemented about a week ago. I don't think there's anything else as far as current status goes, but I did want to clarify that I think part of the problem was just the in-person meetings and everyone being supervised at essentially the same level.
But it sounds like we're getting out of that now, and more in-person contacts are possible. That's what I hear John to say. Is that right, John?
Yeah. The highs are reporting in face-to-face now.
Good. Okay.
And the one thing I'm sure we've explained this multiple times over the last year, but It wasn't simply just a releasing folks based on the Supreme Court order. It was also the lack of authority to issue bench warrants. And so, I looked at Mr. Peterson or Dr. Peterson's statistics, and none of it was all that surprising as far as recidivism right now, because of the fact that, we really weren't seeing people for 9 to 12 months. The court wasn't issuing bench warrants for failures to appear. And, that just extended cases with no contact from the court, which in turn, we were seeing a lot more, repeat cases coming back. Now that has changed since about January, I would like to take a look at 2021 numbers as soon as we can, because I do feel like we're starting to see people more often, and we're not getting quite the same, repeat offenders that we were through 2020.
That makes sense, because now the court can sanction failure to appear.
We can sanction with the bench warrant. We can also, there was a substantial change from the Supreme Court in February, which was, lifting the requirement on omnibus hearings. So defendants are no longer required to be there at omnibus. And so oftentimes now we're having attorneys appear for them. We're having attorneys appear at first appearance and basically put in a waiver for future appearances. So it's minimized the amount of times that defendants have to appear in court, which we would have to look at the numbers, but it seems to me that even though we have the authority to issue warrants, we're getting better contact with the defendants right now and likely resolving more rather than issuing warrants. So.
Oh, that's great. That's really good. I'm glad to hear that.
If I could just follow up on first of all, to apologize for mischaracterizing the monitoring that went on, and the information John and Judge Freeman just provided is really helpful. I will add that yesterday at the whole task force meeting, Tyler Schroeder from the executive's office talked about the funds coming in from the federal act. And those funds are available to the county in substantial amounts through, I think, FY 2024. So based on Judge Freeman's sort of recharacterization of what the need is, which is the continuity of the pretrial services unit, maybe that's where we should focus our thinking about making a budgetary request, would be securing funding for those additional 2 out years beyond what the current funding commitment is. I'll just throw that out as I'm like a dog with a bone. You put money in front of me and I'm not gonna let it out of my jaws. So if there's a different way to frame that can serve our purposes, I'd encourage us to think about doing that.
Okay. Thank you for the clarification. And my concern is that because things went so differently over this past year, we're not going to have the statistical information to give the county council that we had anticipated having. Instead, what we've got are Dr. Peterson's calculations, which are competently done. They just give us bad news because they are so because the incidence of new offenses and FTAs is so high. And that's, I think, explained in large part by the fact that this year was so extraordinary, and the court really did not give any sanctions at all to people who didn't come to their hearings. People who didn't come to their hearings, the court just set a new date for the hearing, which was really necessary given the Supreme Court's order, but didn't produce anything to show how effective pretrial services can be. So I think the numbers that we compile from here on, certainly from here to the end of 2021, are going to be really important in that regard. And we may need to take the bureaucratic steps that are necessary to seek funding for a longer period of time before the end of this year, before we have, you know, an 8-month set of statistics. But, you know, government work was disrupted at every level by the COVID pandemic. I don't think we're going to be blamed in any way for following the Supreme Court's orders. Yeah.
I totally agree with the need for additional time frame as far as the numbers. The one thing that I would add to that is I think our numbers are probably going to be a little bit different even in 2021, both because of COVID, but also comparing them to pre-COVID because of the substantial rule changes that we've seen too. I mean, the fact that the Supreme Court has really narrowed down the hearings that are required of a defendant, I think is going to impact FTAs. At least that's the hope, is that we're going to see less FTAs because defendants aren't going to have to be in there every 30.
Dave, I have not kept up with the Supreme Court's administrative orders since I left office in January. Can you just like summarize paint with a broad brush and tell us what's changed?
Yeah, and it's not one of the administrative orders. This is actually a substantive change to one of the court rules.
Oh,
And
to criminal rules.
yeah, and they kind of signaled that they were going to do this. I'm sure Bruce can probably talk about it more in district court and courts of limited jurisdiction. There was an opinion about a year ago that talked about bench warrants and courts' inherent authority to issue them and really wanting courts to look long and hard before they're just issuing bench warrants for, you know, status hearings and things of that nature. So the Superior Court side, they amended the court rule, I think effective beginning of February, and no longer required defendants to appear at what we call status and omnibus, unless the court finds good cause to require the defendant's appearance. And so far, we have not been finding good cause unless there are specific circumstances.
Does the court have to find good cause to require the defendant to attend? And then if the defendant doesn't attend, that's when the sanctions incur? Or does the court have to, or is it 2 hearings or 1 where that decision gets made?
So typically how it would work is if we have an omnibus hearing, let's say the person FTAs and they haven't been in contact with their attorney, we'll then set that case over for the trial call calendar since that date is already set. If they appear, no sanction, we just reset dates. If they don't appear, then we might issue a bench warrant. Alternatively, if they don't appear at that status hearing and their attorney wants to confirm for trial, we might make a good cause finding to require their presence the Thursday before trial just to ensure that they're actually ready to go. But even that has been fairly rare. Typically, we're taking attorneys at their word that they're ready to go.
Okay, so if the defendant misses the status hearing, there's not a sanction at that point,
Yep.
but there's another chance for the defendant to appear.
Or even again, if they put in an order at first appearance that they're allowing their attorney to appear on their behalf, then certainly we allow them to submit agreed trial setting orders even before that trial. So it's really appear, put in a new trial setting order. Either one of those would satisfy the court unless there's just a flat out FTA.
And the new trial setting order has to have the defendant's signature, right?
Not if they've given authority to their attorney to appear on their behalf.
Oh, okay.
In those hearings.
Okay. So I bet that's making a big difference in bench warrants.
Yeah, it's only been for the past 2 months, so we would have to look at the numbers there, but I get the sense that it has definitely impacted.
You're not issuing any bench warrants at status hearings then,
No.
right?
No.
Wow. And we used to do 6 or 8 of them every status calendar.
And
Yeah.
it gives defense attorneys an additional couple of weeks, well, 3.5 weeks to get in contact with their clients and get them in for the trial call.
Pretrial, yeah. Oh, that's good. I'm really glad they made that rule change. Yeah.
Now, it might skew some of our other numbers that we're looking at because of that, but
Will skew some of our numbers, but it's a good change. Yeah.
Yeah.
And hopefully our defendants who are in touch with pretrial services wouldn't have gotten those bench warrants anyway, because they would have done what they need to do. But it's been a concern of mine for years that if a trial is put off, it can only be put off for 60 days. So that means the defendant ends up with a status hearing every 60 days. And for a trial that goes a year or two before it goes to trial, that's so many status hearings that a defendant is, I think, almost bound to miss one. And so this is a good solution.
yeah, that was the Supreme Court's opinion in that district court case I mentioned. It was that, they have so many hearings that they are at a certain point bound to miss one.
Yeah. Oh, great. I didn't know that happened. But I'm really glad it did. I'm really glad they changed the rule. Good. Okay. Anybody else have, I'm going to ask Andrew to talk a little bit about the information he sent us. Anybody else have any news to report before we get to that? All right, Andrew, Dr. Peterson, can you summarize for us the information you have, including, if you could just paint with a broad brush and summarize the information you sent by email recently and catch us up.
Sure. Let me just thank John, first of all, for sending the information to me. It was a good, clean, easy way to do it. He did a good job with that and made my job a lot easier. So I appreciate that. Thank you, John.
All right, John.
And I also want to put in, maybe a plug for him. And I don't normally delve into county budget issues, but just looking at the numbers, over the past year, out of the roughly 200 people that are on active supervision, almost half of them are in medium or high supervision levels. So, I can imagine that would be a heavier load on his department as well. But taking a look at it, you see that the majority have, and I don't necessarily like the word success or fail. I mean, it's kind of a shorthand for, they either had a new violation or had an FTA on that case. You see more than half of them had one of those two things happen. And we looked at it several different ways. As was mentioned, there's no risk assessment, instrument assessment of their risk level. So it was all the bench assessment. And there are differences as you go down, kind of as you increase the risk from none, or the supervision level from none to high. The people on high supervision failed more often than the people on none, and it kind of stair step down at each level, which you'd expect. But it seems like there's potentially at least room for improvement on picking out who gets none or low or medium or high, just because the numbers were relatively low overall. In terms of who was failing and succeeding on there, or who had new offenses or FTAs, a couple of things surprised me. One, males and females were about the same. That usually you don't see that. Usually there's usually women are much less likely to end up in the system in the first place, and then again. But here, for some reason, that wasn't the case. Racially and using racial and ethnic breakdowns, it was about what we'd expect. Unfortunately, there was some differences there. The strongest being among the Native American populations seemed more likely. The numbers were relatively small, so we have to take several grains of salt with it. But it was there's some disparity there, and that they were much more likely to have a new offense or FTA. And then I just included kind of a breakdown so you could look at new charges and FTAs separately, and then broke it down by age group again. And you see kind of the things we'd expect, that the younger folks are going to be more likely to show up again, have some kind of new offense or FTA. And then there's kind of a line, there's almost like a cliff that happens about age 35 or so, where if a defendant after that age is less likely to have one of those things occur. Then you can look at their criminal history. I just included a little information on their criminal history and their prior offenses and FTAs. And you can see that from there, these are folks that are not necessarily new to the system. They've been in front of a judge once or twice before, at least. Very few of them were there for the first time.
Okay, thank you for that information. Yeah, obviously there's more that this is like preliminary information. We'll want to compare these numbers with the numbers that we derive going forward. And especially to explain, if possible, the racial and ethnic disparities. Oh, go ahead.
Sorry, Judge Garrett. The other thing I was going to say, well, we recognize that these numbers may be a little anomalous based on everything that's happened in the last year. If you do need information about pretrial, as you create a proposal for the county or whomever, this is not the first pretrial group, and there's been research on others, so I could help get some of that information to show that there's at least some statistical support. Whether well, it's not specific to Whatcom County. Research can show that pretrial services in general tend to benefit. And I can help provide some of that information if that would be beneficial.
What jurisdiction would you be looking at there, do you think?
Well, I can see what's available. I don't know if other counties in the state have looked at it. If so, I can try and get that. Otherwise, I'll just find kind of what's available in journals, what's been peer reviewed in terms of reviews of pretrial services and their effects.
I would also be very interested in that information if you're able to find it.
Of course, Bruce, sure.
And certainly in the context of funding requests and justification in general, the task force is charged with pursuing evidence-based practices. So I don't think it requires local evidence necessarily in that kind of context. The best evidence we can muster would be the best evidence there is.
And also from my time on the statewide task force, they came away with, there was a whole subcommittee dedicated to pretrial services, and their recommendation was for counties to, where possible, use pretrial services.
Okay. I think to the extent that you can easily obtain information from other jurisdictions, Dr. Peterson, that would be a good thing. It would also give us an informal model to see how our pretrial services and those results compare to other jurisdictions using pretrial services. So yeah, that would be appreciated if you could do that.
Sure. I seem to always find a way to assign myself my own homework.
You do. You're very good at that, and that's good. You could just mystify us with statistics and then imply that it's our fault that we don't understand. But
I try to avoid that if I can. Yeah, trying to.
yeah, well, and that is much appreciated.
That's the scientific method, isn't it?
It's the subtext of the scientific method. Yeah, it's between them.
Could I ask a question? I appreciate the depth of this information. It's a little bit hard for me to be sure of the scope of it. If I'm reading it correctly, you're looking at the people who are actually released and then tracking. But what we don't have is that group that was released versus the people who were detained. And so, for instance, it's good to know racial disparities, for example, within that group and the outcomes there. But it would be relevant to know that 90% of white people were released, but only 10% of people of color. So there's a component of the data that, if I'm reading this right, is not visible to us. And at some point, it would be nice if we could compile all of that together in a way that would be comprehensible to the layperson.
Sure. Yeah, you're right, Stephen. I appreciate it. That's a very good comment. And actually, I think in a minute, let me talk about something else, but related to that. But first, John, do you have information? Because what you sent me was people on supervision. Do you have the people that were not released for whatever reason?
No, the only
Okay.
thing we would have is we perform the public safety assessment on all new arrestees for first appearance. Unless they bail out, then we won't do it on them.
Okay.
Some of those aren't assigned and some might be. So our software doesn't necessarily separate the two or track those who weren't assigned to us. It's just the way the database is set up.
Sure. Okay. And then I may have to go to the jail to get booking information.
Yeah, I
And
think there's a connection with Spillman you could probably look into.
Oh, okay. That's interesting.
The jail also won't capture those. It's not just those who were released and those who weren't. It's also those who were released but weren't put on services as well, which won't be captured in the jail information. So I don't know how to capture that portion.
Yeah, so I probably need like first appearance information, maybe. Okay. I can see
yeah.
the AOC might have that. I think they should, in fact. So let me dig into that, and then I can kind of compare between those two data sets. That's a good point, Stephen. You're right. That we're looking at just, there are kind of two pieces to this, right? There's the if you want to call it process, so who gets on supervision and who doesn't, and then there's also the outcomes, and that's just for those that were on supervision, and that's what I kind of shared and was talking about today. So yeah, you're right, and that process section needs to be talked about as well. I think that's a very good thing. In terms of definitions, for what I did share, let me back up. Everything is based off the arrest date. So a new offense or an FTA is judged on, did it happen after that arrest date? The FTA, I kind of broke it down two ways. So there's FTA for the current case, and then there's FTA for a different case, for a subsequent case that was not part of this case we're talking about. And that was all based on the case number and the arrest date. So if it was this case, it had to have the same case number, but occur after the arrest date. If it was a subsequent case, it would occur after the arrest date, but have a different case number. Does that make sense? Okay. And there was another thing I was going to say. No, maybe that was it. Okay. Bless you. Any other questions on that? Yes, Stephen.
One more. I was struck by John's comment that people who bail out right off the bat aren't scored under the PSA. And I'm wondering if, for our purposes in justifying the use of the PSA, both to the county council as a budgetary reason and to the community in racial equity discussions, is that a good practice? Would it be to our benefit in either of those conversations to figure out a way to run everybody through the PSA, so we at least have that scoring data, even if it wasn't used by the judicial officers to make a release decision? I'm not sure if I'm even posing that correctly, because I'm just sort of reacting to that point that John made. But do we want to let a cohort of people brought into the system go without having a risk assessment done on them?
I think
I
not.
guess.
I mean, first of all, those numbers are going to be skewed, I would think, to defendants who have more resources. I mean, they're the ones who are going to be able to bail out quickly, right? So it seems we would at least want to know about that.
And again, this isn't just bailout. This could be also weekend probable cause determination where it's a PR release over the weekend.
That's true, yeah.
So,
But still, I mean, it seems it would be good to have these numbers, because if we don't have these numbers, then the numbers of total pretrial release decisions isn't going to be the same as the total of people who've been arrested and booked into the jail. And we'd like those numbers to be as equivalent as possible, don't you think? Yeah, I'm going to take that as a yes from people I see nodding.
I think it would also be helpful to the judicial officer who's covering the arraignment and first appearance, which would typically be about a week later. So, if it's possible to have that done, I think it would probably be a useful tool to have at that time as well.
I want to make a comment that usually the PSA was intended for help with a release decision as a tool. So this would kind of bring in another aspect of, it's more research driven than a tool for release to see detain or release, or what kind of conditions should they release with. That's why we were just doing first appearance in custody. And that's kind of what the tool's intention has been. However, if you did capture everybody, that tool could potentially bring up other statistics. I don't know if the AOC collects all new arrest numbers, and if they're compared to, those released and those not, or under supervision and those who weren't assigned. That'd be a pretty big task, though, I think. So anyway, just thought I'd give that perspective.
Definitely have FTE implications too, right, John?
Most definitely. With the PSA, it's very intensive data entry. It's all done manually, and some cases can take 5 to 7, 12 minutes. Some can take over 30, depending on the arrest history and tracking down. We're trying to minimize human error if it's not automated through the criminal database. And some of that is, failure to appears. What are these warrants? Are they exactly failure to appears? And they do get specific in the PSA what a failure to appear means. And so we got to track that down. And sometimes the easiest way is in the court docket notes. So we're reading from that arrest all the way through on a former case or something. And that can take it can be very intensive.
So John, can you work with Andrew to get him either get him the numbers on the people who are booked and released, or to get him in touch with the people who can get him the numbers? And Dave, perhaps you could be involved in that too, if it involves asking the jail to keep the numbers and get them to us.
Yeah, no problem there. And John made a very good point that this might just be a better statistical analysis versus actual practical use at this point. But
John, can you work with Andrew to either see that he gets those numbers, or if the jail needs to be persuaded to bring Dave into the discussion and have them talk with have him or you or whatever talk with the jail?
Yeah, we get connections to the jail.
Okay, so
We've
you're
got connections.
all right, good. So you're the ones with homework from this meeting so far. Yeah. Okay, good. Next question. Where do we go from here? I'll throw out my 2 cents. It seems to me that what we should do is continue on the path that we're on with the resurgence of pretrial services and the resurgence of the risk assessment evaluation. I don't think we should change anything about the risk assessment tool or the levels of suggested pretrial services. I think we need to see how well we're doing with it before we tinker with it. And we have not used these tools in laboratory conditions yet. Laboratory conditions? In real life conditions. And so we want to do that. It seems to me that our group can meet again in 2 months or so. I will talk with Shuling Zhao about her group's involvement. I think they're going to be intent on setting up with the county before they take on any new projects, but I'd like to set up communications with them. I'd like our group to consider what if we can identify somebody who is active in minority rights and racial equity in Whatcom County and is willing to learn enough about the legal system that they can participate in this work group intelligently. I'd really like for us to appoint that person to this group. But I think we have to identify that person, and the person has to be willing to, come up to speed on the legal process so that they can look at the racial equity issues in context. But it seems to me that we want general input from racial advocacy groups on an ongoing basis, but it also would be nice, if possible, to develop some connections with those groups through an individual who could be on our committee. I've been thinking about who that might be. I've been thinking about in the legal community who that might be. I mean, are there lawyers, prosecutors, or defense lawyers who are involved in activism in that area and also know the criminal justice system in Whatcom County? I haven't been able to, in my own mind, identify anybody who meets both those criteria, but there may be somebody. We should think about that. So I think that for now, what we need to do is stay with the status quo, move along with the systems that we've established and see how they're working for us, and continue our efforts to establish better connections and input with the racial equity and advocacy groups. That's my 2 cents about where I see us over the next 4 to 6 months. Others?
I agree with that general approach. I'll give some thought to anybody we can identify as that target person to join the group. Maybe when Judge Freeman talks to Damani, that he might be another source of a referral. But otherwise, I think that's a good plan. And I'll take this opportunity to bid adieu. I need to drop off for another meeting, but I'll catch up through Jill on what we finalize for our next steps.
Okay, that sounds good. And I'm so glad you could join us for this one, Stephen. That worked out well.
And Stephen, one quick question to follow up on was the funding issue. I was in and out yesterday in the main meeting, so I didn't catch all of Tyler's presentation, but when do we need to have some sort of recommendation on that?
Well, he wasn't specific about that. What he said was that as they understood it at this point, they were likely to get a total of $44 million for the county for 2021 through 2024. And he thought that maybe half of that would be coming in quite soon, May or June. So I think they'll be making some decisions. And obviously, it's a big trough for us all to gather around. But I think the sooner we can tackle some of those recommendations, the better.
Okay.
So I mean, maybe that calls for a separate and sooner conversation in that regard. If we can identify something with adequate justification behind it.
Yeah.
Well, let's stay in touch with each other. We had been setting our meetings every other month, which would make for a meeting. What would it be? The third Tuesday in June.
June 22nd.
Yeah, and in fact, did we put that on the calendar last time, Jill?
Yes, all the meetings for this year are already scheduled.
Okay, well, good. Let's go with that schedule then. And that meeting, we should have some reports back from our various connections with the minority advocacy groups. And we should at least have a couple months of numbers from now until then. So we'd have numbers for April and May for the incarceration, pretrial incarcerations using the pretrial risk assessment. So it'll be more, I think, a meeting of just checking in with each other and being sure we're all on the same page as to the status quo and just moving along. So I would say that the meeting for June 22nd, we should keep that meeting and anticipate that it probably won't be a meeting with huge discussion or decision making, but I think we all need to be aware of status as we move ahead. Does that make sense?
And if I could make my final suggestion, perhaps Judge Freeman and John could sit down with Dave Reynolds and at least flesh out the questions of would we target longevity and stability of the unit versus staffing levels or some combination of the two, just so that the key input was all coordinated in that respect.
That makes good sense. And if we need to do something in terms of a financial request to the county council or others before that June deadline, please let me know, Judge Freeman and John, and we'll make a plan to have another meeting to do whatever we need to do to make that request. Okay?
Yep.
Yeah.
All right. So Judge Freeman, you're the one walking out with the most homework.
No problem.
All right. Okay.
Thank you, everyone.
Thank you all. I think that we're moving along. That's good.
Yeah.
All right. We'll see you in June, if not before.
Okey-doke.
Thanks.